I never thought my retirement in Scottsdale, Arizona would turn into a legal nightmare, but Karen Brennan had other plans for me. The first violation notice arrived on a Tuesday morning in March, taped to my front door like some kind of scarlet letter, claiming my mailbox was the wrong shade of beige. My name is Jacob Peterson, and I had moved into the Sagebrush Estates community 6 months earlier after selling my software company in Seattle. The place seemed perfect. Well-maintained streets, beautiful desert landscaping, and a quiet neighborhood where I could finally relax and work on my woodworking hobby. The HOA seemed reasonable enough during the home buying process, just the standard rules about keeping your property neat and following the architectural guidelines. I should have known better. Karen Brennan was the vice president of the HOA board, a woman in her late 40s with an aggressive blonde bob haircut and the kind of permanent scowl that suggested she had spent her entire life looking for things to complain about. I had met her briefly at a neighborhood barbecue shortly after moving in, where she had spent 20 minutes lecturing me about the proper way to position my trash cans on collection day. I smiled politely and made a mental note to avoid her whenever possible. The mailbox violation notice was confusing because I had not painted or changed my mailbox in any way. It was the same standard desert tan color that came with the house, identical to every other mailbox on my street. I called the HOA management office and spoke to a tired-sounding administrator named Rita who promised to look into it. She called me back an hour later and said the complaint had been filed by Karen Brennan herself, but Rita could not see any issue with my mailbox. She said she would mark the violation as resolved and not to worry about it. I thought that was the end of it. I was wrong. 2 weeks later, another notice appeared on my door. This time, Karen claimed I was storing a commercial vehicle in my driveway, which violated the community covenants. The supposed commercial vehicle was my 12-year-old Ford F-150 pickup truck that I used for hauling lumber and supplies for my woodworking projects. It was a standard consumer truck, dark blue, with no business logos or signage of any kind. I had checked the HOA rules specifically before buying it to make sure it would be allowed. I took photos of my truck from every angle and emailed them to the HOA office, along with a copy of the covenant section that specifically allowed personal trucks under 1-ton capacity. Rita apologized again and said she would handle it. She mentioned that Karen had been becoming increasingly aggressive with violation reports lately and that other residents had complained too. The third notice came a week after that. Karen reported that I was running an illegal business from my home because I had received multiple deliveries from commercial suppliers. Those deliveries were wood, hardware, and tools for my woodworking hobby, which I pursued purely for personal enjoyment. I had built exactly 3 pieces of furniture: a bookshelf for my office, a coffee table for my living room, and a workbench for my garage. I had not sold anything or conducted any business whatsoever. This time, I decided to go directly to Karen's house and speak with her in person. It was a Saturday afternoon, and I found her in her front yard, inspecting her neighbor's hedge with the intensity of a military officer examining troops. "Karen, we need to talk," I said as I approached her property line. She turned to look at me, and her expression immediately hardened. "Mr. Peterson, what do you want?" "I want to know why you keep filing false violation reports against me. My mailbox is the correct color, my truck is not commercial, and I am not running a business." "Those reports are all legitimate concerns," she said, crossing her arms. "This is a prestigious community, and we have standards to maintain." "Standards that I am following," I replied, keeping my voice level. "You are wasting everyone's time with these fake complaints." "How dare you call them fake?" Karen said, her voice rising. "I have every right to report violations when I see them. If you do not like living in an HOA community, maybe you should move somewhere else." "I am not going anywhere," I said, "but you need to stop harassing me." Karen stepped closer to her property line, her face flushed with anger. "Harassing you? You do not know what harassment is. I am protecting this neighborhood from people who think the rules do not apply to them. Now get off my property before I call the police." I was standing on the sidewalk, which was public property, but I decided this conversation was going nowhere. I walked back to my house, frustrated but determined not to let her get to me. The violation reports did not stop. Over the next 2 months, Karen filed complaints against me for supposedly leaving my garage door open after 7 p.m., which was not a rule that existed anywhere in our covenants. She reported me for having lawn furniture that was supposedly not approved, even though it was identical to Seth's. I could see in at least 6 other yards. She claimed I was creating noise disturbances with power tools at inappropriate hours, even though I only worked in my garage between 10 a.m. and 4 p.m. on weekdays, well within the allowed times. Each time, I had to document everything, take photos, review the actual HOA rules, and submit detailed responses to the management office. Rita was sympathetic, but explained that she had to process every complaint that came in, regardless of its merit. The violations were creating a file against my property, and even though none of them resulted in actual fines, they were becoming a permanent record that could affect my ability to sell the house later. I started documenting everything. I installed security cameras around my property that time-stamped every recording. I kept a detailed log of my activities, noting when I was home, when I used power tools, when I put out my trash cans, when I received deliveries. I photographed my property weekly from multiple angles. I was building a defense file because I knew this was escalating. In June, Karen filed a complaint claiming that I had painted my front door without HOA approval. The door was the same color it had been when I bought the house, a dusty red tone that matched dozens of other doors in the neighborhood. I had not painted anything. I pulled up the listing photos from when I purchased the property and showed that the door was identical. Rita apologized yet again. "Mr. Peterson, I know this is frustrating," Rita said over the phone. "Between you and me, Karen has been on a rampage lately. She has filed over 40 violation complaints in the past 3 months against various residents. The board is starting to have concerns about her behavior." "Then why does not anyone stop her?" I asked. "It is complicated." "She is vice president, and technically, any board member or resident can file complaints. We have to process them all. But I would recommend you attend the next board meeting and address this directly with the full board." I marked the date on my calendar. The next HOA board meeting was scheduled for the 3rd Thursday of June at the community clubhouse. Before the meeting could happen, Karen escalated things dramatically. I received a certified letter from a law firm representing the HOA, stating that I was being fined $1,500 for multiple violations, and that if I did not pay within 30 days, a lien would be placed on my property. The letter listed 7 different violations, all of them completely fabricated or grossly misrepresented. I called the management company immediately. Rita sounded shocked when I told her about the letter. "I did not authorize that," she said. "The board has not voted on any fines for your property. Let me make some calls and get back to you." She called me back within an hour, sounding stressed. "Karen sent that letter without board approval. She apparently has a friend who is an attorney and convinced him to send it on HOA letterhead. This is completely improper. I am so sorry, Mr. Peterson. The The board president is furious. There is going to be an emergency meeting tonight. I want to be there, I said. You have every right to be. 7 p.m. at the clubhouse. That evening, I arrived at the clubhouse 30 minutes early with a thick folder containing all my documentation. Photos, time-stamped videos, copies of the actual HOA covenants with relevant sections highlighted, my home purchase records, and a detailed timeline of every fake violation Karen had filed. The clubhouse was a modest single-story building with a meeting room, a small kitchen, and a fitness center. The board president, a retired accountant named Donald Green, arrived shortly after I did. He was a thin man in his 60s with gray hair and wire-rimmed glasses. He shook my hand with a grave expression. "Mr. Peterson, I owe you an apology on behalf of the board. What has happened here is completely unacceptable. Karen had no authority to send that letter, and the attorney who sent it is going to be hearing from our actual HOA counsel." "I appreciate that," I said, "but this has been going on for months. She has been systematically harassing me with fake violations." "I know, and we are going to address it tonight. I have reviewed all the complaints she filed against you, and I cannot substantiate any of them." This is a serious problem. Other board members arrived. A woman named Patricia who worked as a nurse, and a man named Stephen who owned a dental practice. Karen arrived last, striding in with her usual confidence, apparently unaware that she was walking into an ambush. The meeting began with Donald explaining that this was a special session called to address concerns about violation reporting procedures. Karen sat with her arms crossed, looking irritated that her evening had been interrupted. "Karen, we need to discuss the letter that was sent to Mr. Peterson," Donald began. "What about it?" Karen said. "He has been violating community standards for months. Someone had to take action." "You did not have the authority to authorize legal correspondence on behalf of the HOA," Donald said firmly. "That requires a board vote. You also do not have the authority to levy fines. That also requires a board vote. What you did was illegal." Karen's face reddened. "I was protecting this community. You all have been too soft on violators. If I had not stepped up, our property values would be plummeting." "Mr. Peterson, would you like to present your documentation?" Donald asked. I spent the next 20 minutes walking through every fake violation Karen had filed. I showed photos proving my mailbox had never been painted. I showed the truck specifications proving it was not a commercial vehicle. I showed delivery records and my personal woodworking projects proving I was not running a business. I showed time-stamped camera footage proving I was not violating noise ordinances or leaving my garage door open at inappropriate times. I showed my home purchase records proving my front door had never been repainted. Every single complaint she filed against me was either completely false or a gross misrepresentation of the facts, I concluded. She has been harassing me for months, wasting the management company's time, and now she sent a fraudulent legal threat. This has to stop. Patricia looked at Karen with disappointment. "Karen, do you have any evidence to support these violations?" "I know what I saw," Karen said defensively. "His mailbox looked wrong. His truck looks commercial. He is always getting deliveries. Just because he has some photos does not mean he is innocent." "You filed a report saying he painted his front door," Stephen said, looking at the documents. "His purchase records clearly show the door was already that color." "It looked freshly painted," Karen insisted. "Based on what?" Donald asked. "Your feeling." "That is not how this works, Karen. We have rules and procedures. You cannot just file violations because you think something looks wrong. You need actual evidence." The argument went on for another 30 minutes. Karen refused to admit she had done anything wrong, insisting that she was just being thorough and that the neighborhood would fall apart without her vigilance. The other board members grew increasingly frustrated with her. Finally, Donald called for a vote to censure Karen and temporarily suspend her violation reporting privileges. The vote was 3-1, with only Karen voting against it. She stormed out of the meeting, slamming the door behind her. "Mr. Peterson, again, I apologize," Donald said after she left. "All of those violations are being removed from your record. There will be no fines, no penalties. We are also going to be reviewing all of Karen's other recent violation reports to see if this pattern extends to other residents." "I appreciate that," I said. "But what is to stop her from continuing to harass me in other ways?" Donald sighed. "Honestly, I do not know. We can limit her role on the board, but we cannot stop a resident from being a difficult neighbor. If she continues to harass you outside of HOA channels, that might be a legal matter between you and her personally." I went home that night feeling somewhat vindicated but not satisfied. I knew Karen was not going to just let this go. I was right. 3 days later, I found a long scratch along the passenger side of my truck. It looked like someone had taken a key or a screwdriver and dragged it along the entire length of the vehicle. My security cameras faced the front of my house and garage, but my truck had been parked on the street, just out of view. I filed a police report, but without video evidence or witnesses, there was not much they could do. The officer who took my report suggested I park in my garage from now on. The next week, someone dumped a bag of garbage on my front lawn in the middle of the night. Again, it happened just out of range of my cameras. I cleaned it up and adjusted my camera angles to cover more area. Then Karen filed a complaint with the city of Scottsdale, claiming I was violating zoning laws by running a commercial woodworking business from my residential property. A city inspector showed up at my door one Tuesday morning with a clipboard and a confused expression. "Mr. Peterson, I am here to inspect your property regarding a commercial business complaint," he said. I invited him in and showed him my garage workshop. He looked around at my personal tools and the bookshelf I was currently building for my bedroom. "This is a hobby?" he asked. "Yes, completely personal. I have never sold anything or conducted any business." He made some notes on his clipboard. "You are clearly not running a business. This is less equipment than a lot of hobbyists have. I will mark this complaint as unfounded. Do you know who filed it?" "Yes, a neighbor who has been harassing me, Karen Brennan." He wrote down her name. "If she files false complaints with the city again, she could face penalties. Filing false reports wastes city resources." After he left, I decided enough was enough. I called a lawyer. The attorney I hired was named Michael Rodriguez, a civil litigation specialist who came highly recommended by a friend in Seattle. His office was in downtown Scottsdale, in a modern building with floor-to-ceiling windows. Michael was in his 40s, sharp-eyed and professional, and he listened intently as I explained the entire situation. "So you want to sue her for harassment?" Michael asked. "I want to sue her for fraud and defamation," I said. "She filed fake HOA violations, sent a fraudulent legal demand, damaged my property, and filed a false complaint with the city. She has been conducting a deliberate campaign to harm me." Michael leaned back in his chair, thinking. Fraud is an interesting angle. In Arizona, civil fraud requires proving that someone made a false representation with intent to deceive, and that you suffered damages as a result. The fake HOA violations could potentially qualify, especially the fraudulent legal demand letter. Defamation would require proving she made false statements about you to third parties that damaged your reputation. "She told the HOA board I was running an illegal business," I said. She told the city the same thing. She filed dozens of false violation reports that are part of my property record. That could work, Michael said. Defamation, fraud, intentional infliction of emotional distress, and possibly harassment. We would need to prove damages. Have you suffered financially? I have spent hundreds of hours dealing with this. I paid for security cameras. My truck has damage that cost $800 to repair, and I have had to hire you. Plus, the fake violations could affect my property value if I try to sell. Okay, that is a start. Let me draft a demand letter first. We will lay out all the false complaints and the damages, and we will demand that she cease all harassment and pay compensation. If she refuses, we file suit. The demand letter was sent to Karen via certified mail in early July. It was 5 pages long, meticulously detailing every false violation, the fraudulent legal demand, the property damage, the false city complaint, and the emotional distress caused by her campaign of harassment. We demanded $10,000 in damages and a written agreement that she would cease all contact with me. Karen responded through her own attorney, the same one who had sent the fake HOA demand letter. His response was dismissive and aggressive, claiming that Karen had every right to file HOA complaints and city reports, that she had no obligation to pay anything, and that if we pursued legal action, they would countersue for malicious prosecution. Well, that answers that, Michael said when he showed me the response. We are filing suit. Let us make this very thorough. The lawsuit was filed in Maricopa County Superior Court in late July. We sued Karen Brennan individually for fraud, defamation, intentional infliction of emotional distress, and property damage. The complaint was 30 pages long and included exhibits documenting every false violation report, every piece of evidence proving they were false, the fraudulent legal demand, the city complaint, and the timeline of harassment. Karen was served with the lawsuit at her home by a process server. According to the server's report, she became irate and slammed the door in his face after snatching the papers from his hands. The discovery phase of the lawsuit began in September. We subpoenaed records from the HOA management company, showing every violation Karen had filed against me and against other residents. The pattern was damning. Over the past year, Karen had filed over 200 violation complaints against various residents in Sagebrush Estates. The HOA management company had substantiated fewer than 15 of them. She was filing false reports against everyone, not just me. We deposed Karen in October at Michael's office. She arrived with her attorney, a nervous-looking man named Brad Fletcher who seemed to realize his client was in serious trouble. Karen was belligerent from the start, refusing to admit she had done anything wrong. Mrs. Brennan, did you inspect Mr. Peterson's mailbox before filing the violation report claiming it was the wrong color? Michael asked. I did not need to inspect it up close. I could see it from the street. And what about the mailbox appeared to be the wrong color? It just looked off. Can you be more specific? It was lighter than it should have been. Did you compare it to the approved color chart? I did not need to. I know what the correct color looks like. Michael pulled out photos of my mailbox next to my neighbor's mailboxes, all identical colors. These photos show that Mr. Peterson's mailbox is the same color as the surrounding mailboxes. Why did you single his out? Karen hesitated. Maybe the lighting was different when I saw it. Or maybe the mailbox was never the wrong color and you filed a false report. I filed a report based on what I observed. The deposition went on for hours. Michael systematically went through each fake violation, forcing Karen to either admit she had no evidence or to make increasingly absurd justifications. By the end, even her attorney looked exhausted. We also deposed other residents Karen had targeted. A woman named Sandra testified that Karen had filed a complaint claiming Sandra's rose bushes were overgrown, even though they had been professionally trimmed the day before. A man named Robert testified that Karen reported him for parking a boat in his driveway, even though he had never owned a boat, and the HOA rules allowed boats anyway. An elderly couple named George and Martha testified that Karen had reported them for not maintaining their lawn, even though they paid a professional landscaping service that came weekly. The evidence was overwhelming. Karen had been conducting a systematic campaign of filing false violations against residents throughout the community, and I had simply been her most recent and most persistent target. In December, as we were preparing for trial, something unexpected happened. The HOA board held a vote to remove Karen from her position as vice president. Donald Green called me to let me know. We reviewed all her violation reports over the past 2 years, Donald explained. Out of over 400 complaints she filed, fewer than 30 were actually valid. She wasted thousands of hours of management company time and created enormous stress for dozens of residents. The board voted unanimously to remove her. We also passed a new rule requiring all violation complaints to include photographic evidence and specific citations of which rule is being violated. That is good to hear, I said. There is more. Several other residents she harassed are considering joining your lawsuit as co-plaintiffs. She has caused a lot of damage to this community. Michael and I discussed whether to add additional plaintiffs, but ultimately decided to keep the case focused on my specific damages. However, the testimony from other victims would be powerful evidence showing Karen's pattern of behavior. As the trial date approached in February, Karen's attorney reached out about settlement discussions. We met at a mediator's office in Phoenix, a neutral third-party attorney who specialized in helping parties resolve disputes before trial. Karen looked miserable. The stress of the lawsuit had clearly taken its toll. Her aggressive confidence was gone, replaced with a drawn, tired appearance. The mediator explained the process, and then separated us into different rooms to discuss settlement terms. Michael and I started with our position. We wanted $50,000 in damages to compensate for all the time, stress, legal fees, and harm to my property and reputation. After several hours of back and forth, with the mediator shuttling between rooms, Karen's attorney came back with an offer of $5,000 and an agreement to leave me alone. Not even close, Michael told the mediator. We have an overwhelming case. We have documented proof of fraud, defamation, and harassment. We have testimony from multiple witnesses showing a pattern of behavior. We have evidence of property damage. If this goes to trial, we will win, and the judgment will be much higher than $50,000 once we add in punitive damages. The mediation broke down without an agreement. We were going to trial. The trial began on a Monday morning in late February at the Maricopa County Superior Court. The courtroom was modern and businesslike, with wood paneling and fluorescent lights. The judge was a no-nonsense woman in her 50s named Judge Rebecca Thornton. Jury selection took most of the first day. We ended up with a jury of 7 people, 4 women and 3 men, ranging from a young woman in her 20s who worked in retail to a retired engineer in his 70s. Michael's opening statement was clear and direct. He explained how Karen had systematically filed false violation reports, sent a fraudulent legal demand, damaged my property, and filed a false city complaint, all as part of a deliberate campaign of harassment. He promised to prove every element with documentation and testimony. Brad Fletcher's opening statement for Karen tried to argue that she had simply been doing her duty as an HOA board member, and that any mistakes were honest errors in judgment, not fraud. He claimed I was oversensitive and vindictive, turning simple neighborhood disputes into a federal case. I was the first witness. Michael walked me through the entire timeline of Karen's harassment, and I explained each fake violation and how I had documented the truth. I kept my emotions in check and presented the facts clearly. Brad's cross-examination tried to suggest I had a personal vendetta against Karen, but I calmly pointed out that I had tried to resolve things peacefully multiple times before resorting to legal action. Michael called Rita from the HOA management company as a witness. She testified about the massive volume of false complaints Karen had filed and the resources wasted investigating them. She brought records showing that Karen had filed more complaints than all other board members and residents combined, and that her substantiation rate was less than 10%. We called several other residents who testified about their experiences with Karen's false violations. Their stories painted a picture of someone who was obsessed with finding violations whether they existed or not. We called the city inspector, who had come to my house. He testified that my property clearly had no commercial business and that the complaint was obviously false. Michael presented the security camera footage showing my property and the time-stamped evidence proving I had not committed any of the violations Karen claimed. We presented the fraudulent legal demand letter and had a legal ethics expert testify that sending such a letter without proper authorization was improper and potentially fraudulent. Brad called Karen to the stand in her defense. It was a disaster. She came across as defensive and unreasonable, insisting that she had been right to file all the violations even when confronted with photographic evidence proving they were false. She claimed she was just trying to maintain standards and that people like me were ruining the neighborhood. "Do you admit that Mr. Peterson's mailbox was the correct color?" Michael asked during cross-examination. "It looked wrong to me," Karen insisted. "But it was the correct color, yes or no?" "I suppose so, but—" "Yes or no, Mrs. Brennan?" "Yes." "And you filed a violation report anyway?" "I thought it looked wrong at the time." "Did you verify your belief before filing the report?" "I did not think I needed to." Michael repeated this pattern for each violation, forcing Karen to admit she had filed reports without proper evidence. She grew increasingly flustered and angry, which only made her look worse to the jury. Brad tried to rehabilitate her on redirect, but the damage was done. Karen had come across as exactly what she was: a petty, unreasonable person who filed false complaints without caring about the truth. Closing arguments happened on Friday afternoon. Michael summarized all the evidence and argued that Karen had committed fraud by knowingly filing false reports and sending a fraudulent legal demand. He argued that she had defamed me by telling the HOA board and the city that I was running an illegal business. He argued that her campaign of harassment had caused me significant emotional distress and financial harm. He asked the jury to award $50,000 in compensatory damages and additional punitive damages to punish Karen's malicious behavior and deter others from similar conduct. Brad argued that Karen had made honest mistakes and that I had not suffered sufficient damages to justify a large award. He asked the jury to find in Karen's favor, or, at most, award minimal damages. Judge Thornton instructed the jury on the law, explaining the elements of fraud, defamation, and intentional infliction of emotional distress. The jury deliberated for about 5 hours before reaching a verdict. We all stood as the jury filed back in. The foreperson, a middle-aged man who worked as a project manager, handed the verdict form to the bailiff, who handed it to Judge Thornton. She reviewed it silently, her expression neutral, then handed it back to the bailiff to read aloud. In the matter of Peterson versus Brennan, we the jury find in favor of the plaintiff Jacob Peterson on the count of fraud. We award compensatory damages in the amount of $35,000 and punitive damages in the amount of $50,000. My heart pounded as the bailiff continued. On the count of defamation, we find in favor of the plaintiff and award damages in the amount of $15,000. On the count of intentional infliction of emotional distress, we find in favor of the plaintiff and award damages in the amount of $20,000. Total damages awarded, $120,000. Karen made a choking sound. Her face went pale. Judge Thornton thanked the jury and dismissed them, then set a schedule for post-trial motions. Brad immediately indicated he would be filing a motion for a new trial or reduction of damages, but Judge Thornton looked skeptical. Michael shook my hand as we left the courtroom. That is an excellent verdict. The jury clearly believed you and wanted to punish her behavior. What happens now? I asked. They will file post-trial motions arguing the damages are excessive, but I doubt the judge will reduce them substantially. Then Karen has to pay, or we start the collection process. If she does not pay voluntarily, we can put liens on her property, garnish wages, seize assets. Brad's post-trial motions were denied 3 weeks later. Judge Thornton ruled that the damages were supported by the evidence, and that Karen's conduct was indeed malicious and deserving of punishment. The judgment was finalized. Karen Brennan owed me $120,000, plus interest and court costs, bringing the total to approximately $135,000. Karen did not pay. Her attorney sent a letter saying she did not have that kind of money available and requesting a payment plan. Michael responded that we would accept a payment plan only if it was secured by a lien on her house and included interest. Karen refused. We filed to place a lien on Karen's house and began the collection process. The lien meant she could not sell or refinance her house without paying the judgment first. We also filed to garnish her wages. Karen worked as an office manager for a dental practice, and we were able to garnish 15% of her paycheck. At the rate of wage garnishment, it would take her years to pay off the judgment. After 2 months of garnishment, Karen's attorney reached out again about settlement. My client is willing to sell her house to pay the judgment, Brad said during a conference call. But she needs some time to prepare the property for sale and find somewhere else to live. Michael and I agreed to pause collection efforts for 90 days to allow Karen to sell her house, with the understanding that if she did not make substantial progress toward sale, we would resume aggressive collection. Karen listed her house in May. The real estate market in Scottsdale was strong, and her house was in a desirable community despite all the HOA drama. She received an offer within 3 weeks and closed on the sale in June. The sale price was $390,000. After paying off her mortgage and closing costs, Karen netted about $170,000. My judgment took $135,000 of that, leaving her with $35,000 to start over somewhere else. I received the payment via wire transfer on a Wednesday afternoon in late June. Michael called me to confirm the funds had arrived and that the case was finally closed. "Congratulations," he said. "You fought back against a bully and won." Hopefully, this sends a message to other HOA board members that they cannot abuse their power without consequences. After paying Michael's legal fees, I netted about $85,000. It was not about the money, though. It was about standing up to someone who thought she could harass and intimidate people without consequences. Karen moved out of Sagebrush Estates in July. I saw the moving truck from my window but did not go out to watch. I had no interest in gloating or rubbing salt in the wound. I just wanted her gone. The HOA board elected a new vice president, a retired teacher named Linda who seemed reasonable and kind. Donald Green sent out a newsletter to all residents explaining that the board had implemented new procedures for violation reporting, and that they were committed to fair enforcement of reasonable rules. The atmosphere in the neighborhood changed noticeably after Karen left. People seemed more relaxed, more willing to chat with neighbors. I learned that I had not been the only one living in fear of Karen's arbitrary violation reports. Several neighbors thanked me for standing up to her. I went back to enjoying my retirement. I finished the bookshelf I had been building and started on a dining room table. I joined a local woodworking club and made some friends. I took up hiking in the beautiful desert preserves around Scottsdale. Life returned to the peaceful routine I had envisioned when I moved to Arizona. About 6 months after Karen moved out, I ran into Rita from the HOA management company at a local coffee shop. She recognized me and came over to say hello. "Mr. Peterson, I just wanted to tell you again how sorry I was about everything that happened with Karen," she said. "That situation was a nightmare for everyone." "It is over now," I said. "How are things going with the HOA?" "So much better. The new board is reasonable, and violation complaints have dropped by about 90%. Turns out Karen was responsible for almost all of them. The residents are happier, my job is less stressful, and the community is thriving." "That is good to hear. I also wanted you to know that your case has become a bit famous in HOA management circles. It is being used as a training example of what happens when board members abuse their power. You might have helped a lot of people beyond just your own neighborhood." That made me smile. Maybe some good had come from all the stress and expense after all. One afternoon in December, almost a year after the lawsuit began, I was working in my garage when my doorbell rang. I opened the door to find Donald Green standing there with a gift basket. "Donald, what is this?" I asked. "Just a token of appreciation from the board," he said. "We know you went through hell because of Karen, and we wanted to thank you for handling it with such grace and for not blaming the entire HOA for one person's bad behavior. I appreciate that. Do you want to come in?" We sat in my living room, and Donald filled me in on the latest neighborhood news. The HOA had used the lessons from the Karen situation to completely overhaul their violation procedures. Now all complaints had to include photographic evidence and specific rule citations, and all fines required a hearing where the homeowner could present their side. The board had also implemented term limits to prevent any one person from accumulating too much power. "It is ironic," Donald said. Karen was obsessed with maintaining property values, but her harassment was actually driving property values down because people did not want to live here. Now that she is gone and we have reformed our procedures, property values have increased about 8% in the past year. After Donald left, I sat on my back patio and watched the sun set over the desert. The sky turned brilliant shades of orange and pink, and the temperature dropped to a comfortable coolness. I thought about everything that had happened over the past year and a half. I had moved to Scottsdale looking for peace, and had instead found myself in a legal battle that consumed months of my life. But I had also learned that sometimes you have to stand up to bullies, even when it is difficult and expensive. If I had just accepted Karen's harassment, it would have continued indefinitely. and she would have kept abusing other residents too. By fighting back, I had not only protected myself but also helped reform a broken system and freed an entire neighborhood from the tyranny of one unreasonable person. The lawsuit had forced the HOA to examine its procedures and implement reforms that would prevent future Karens from abusing their power. The money I won was nice, but the real victory was knowing that I had stood up for myself and for what was right. Karen had tried to use fake violations and fraudulent legal threats to bully me into submission, and instead she had lost her position, her reputation, and ultimately her house. I never saw Karen again after she moved out. I heard through the neighborhood grapevine that she had moved to a condo in Temp, outside of any HOA jurisdiction. Maybe she learned her lesson, or maybe she would find new people to harass. Either way, she was not my problem anymore. Life in Sagebrush Estates became everything I had hoped it would be when I first moved in. I got to know my neighbors as actual people rather than potential targets of HOA violations. I hosted a couple of barbecues and went to others. I joined the community book club and the neighborhood watch. I became friendly with Linda, the new HOA vice president, who turned out to be a passionate gardener and gave me tips on growing vegetables in the desert climate. My woodworking hobby flourished. I built furniture for my house, then started taking requests from friends. I was careful to keep it purely as a hobby and not accept money, having learned my lesson about even the appearance of running a business from home. The irony was not lost on me that Karen's false accusations about my woodworking business had nearly become a self-fulfilling prophecy when I considered whether to actually start selling my work. The security cameras I had installed to protect myself from Karen became useful in other ways. They captured a package thief who had been hitting our neighborhood, leading to an arrest. They recorded footage of a coyote family passing through my yard at night, which was fascinating to watch. They gave me peace of mind that if anything ever happened again, I would have evidence. I stayed in touch with Michael Rodriguez, my attorney. He told me that my case had indeed become well known in Arizona legal circles as an example of successfully suing for HOA harassment. He had been contacted by several other homeowners who were dealing with similar situations, and he had been able to use the precedent from my case to help them. "You did something important," Michael told me during one of our occasional lunches. HOAs serve a legitimate purpose, but too often they attract petty tyrants who abuse their power. Your case established that there are real consequences for that abuse. It is making a difference. About 18 months after the trial, I received an unexpected letter in the mail. It was from Karen. My first instinct was to throw it away unopened, but curiosity got the better of me. The letter was handwritten, not typed, and it was surprisingly humble in tone. Karen wrote that she had been doing a lot of reflecting since the lawsuit and had realized that she had been out of control. She said she had started seeing a therapist who helped her understand that her obsession with HOA violations had been a way of exerting control in a life where she felt powerless in other areas. She apologized for the harassment and the stress she had caused, and she said she hoped I was doing well. She did not ask for anything or try to justify her behavior, just acknowledged it and apologized. The letter felt genuine. I showed it to my neighbor Sandra, who had been one of Karen's other victims. She read it carefully and handed it back. "What are you going to do?" Sandra asked. "Nothing," I said. "I appreciate the apology, but I do not need to respond. That chapter of my life is closed." "Fair enough," Sandra said. "Though it does take courage to apologize like that. Maybe she really has changed." "Maybe," I agreed, "but that is her journey, not mine." I filed the letter away and did not respond. Karen had caused me too much stress and expense for me to welcome any kind of ongoing relationship, even a cordial one. The apology was nice, but it did not change what had happened. As time went on, the Karen situation became more of a funny story I told at parties than a source of stress. When people asked why I had moved to Arizona, I would sometimes tell them about the retired software guy who got sued by his HOA and ended up suing back and winning. It always got a good reaction. The truth was that the whole experience had taught me valuable lessons about standing up for yourself and not letting people push you around, even when they have some kind of official authority. It had also taught me the importance of documentation. Those security cameras and the detailed records I kept had been crucial to winning the case. I also learned that sometimes the system works. The courts had listened to my case, examined the evidence, and delivered justice. The HOA board had recognized there was a problem and taken action to fix it. The community had rallied behind me rather than protecting the bully. It restored some of my faith in institutions and in people. 2 years after the trial, I was at a neighborhood meeting when Linda announced that Sagebrush Estates had won an award from the Arizona HOA Association for Best Governance Practices. Our HOA's reforms, born out of the disaster with Karen, had become a model for other communities. We could not have achieved this without learning from our mistakes, Linda said during her acceptance speech. A couple of years ago, we had a serious problem with violation reporting that was hurting our community. We faced it head-on, made comprehensive reforms, and came out stronger. I am proud of how this board and this community responded to adversity. People applauded, and several neighbors glanced my way with knowing smiles. I appreciated that Linda had not called me out by name, but people knew what she was referring to. After the meeting, Donald Green pulled me aside. "You know, none of those reforms would have happened without your lawsuit. You forced us to confront an ugly truth about how our HOA was being run. Thank you for that." "I did not have much choice," I said, "but I am glad something positive came from it. More than you know. We have been contacted by HOAs all over Arizona asking about our procedures. Your case is having ripple effects throughout the state." That was satisfying to hear. The lawsuit had cost me time and money and stress, but it had achieved something beyond just my personal vindication. As I drove home that night, I reflected on how different my life was from what I had expected when I moved to Scottsdale. I had anticipated peaceful retirement days filled with woodworking and hiking, not legal battles and HOA drama. But sometimes life throws unexpected challenges at you, and all you can do is face them with integrity and determination. The house Karen had been forced to sell had been purchased by a young couple with 2 small children. They were friendly and quiet, and their kids sometimes played in the front yard, filling the street with happy noise. It was a much better energy than what Karen had brought to the neighborhood. I continued to live peacefully in Sagebrush Estates, enjoying my retirement and my hobbies. The nightmare with Karen became a distant memory, just another chapter in a long life full of unexpected twists. I had moved to Arizona looking for peace, had found conflict instead, but had emerged victorious and had even helped improve things for others along the way. Sometimes I wondered what Karen was doing and whether she had really changed, but mostly I did not think about her at all. She was part of my past, and I was focused on my future. I had good neighbors, a beautiful house, fulfilling hobbies, and the satisfaction of knowing I had stood up to a bully and won. That was more than enough.